on YouTube. Right. Welcome, everyone. This is a new session on our webinar on the use of force. Today we have a very special guest. We have Christoph Haynes, Professor Christoph Haynes, and he's going to speak about the use of force. And Professor Haynes was a rapporteur for extrajudicial executions from the United Nations. He is currently member of the member of the expert committee in human rights of the United Nations. He is professor of the University of Pretoria, and he is director of the Center of Comparative Law in South Africa. Welcome, Professor Haynes. Thank you for being with us today.
Thank you very much for having me.
I want you to, if you could start your presentation. Thank you.
Yes, very good. Thank you very much for this opportunity, Xavier and colleagues. And indeed, sorry. So indeed, I think there have been a lot of developments in the field of the use of force by the police, less lethal weapons. And I would like to say something about that, and I look forward to our discussion. I've, of course, in my own capacity and as a member of the Human Rights Committee, followed developments in Chile very closely and at times with great concern. So I really appreciate this opportunity to talk to you and also to encourage further engagement. I want to recognize my colleague Hernan Casada, who's on the Human Rights Committee with me, was also involved in drafting the general comment. So we had meetings up to 6 o'clock. It was starting from 12:30, and then I would always see he sits in the dark because we have these different time zones. So where I'm in Pretoria now, it's now 4 o'clock, but good morning to all of you. So let me just mention that from the perspective of the United Nations, I think a lot has happened in the last 5 years, and that's what I want to focus on. But also to say that a number of us at the Center for Human Rights, where I'm at the University of Pretoria, are following the domestic laws on the use of force by the police, and also the domestic laws on demonstrations around the world. And we have 2 websites which I'd like to mention to you where we cover these laws, and we would very much welcome any inputs that you have. It's a bit like a Wikipedia kind of thing, where we ask people to send us information, and we put it, what we find we put, and what people send us we put there as well. So the one, I can put it in the chat box later as well, but it's www.policinglaw.info. And the other one is www.rightofAssembly.info. So I'll put that on the chat box so that you have the reference. And I've also distributed a small document where I set out the main ideas with links and so on. And actually this, the link to the website, I think, is on that particular document as well. So I think it's perhaps useful to start with the international standards on the use of force, just as a sort of a frame of reference, and then to say something about the more recent developments that we've seen. And also to emphasize that from the UN side, we will have in October, we will have a large webinar on the use of force, probably with the High Commissioner for Human Rights, and with other experts who've worked in this field. And Xavier, I will send you the information on that, and you are most welcome to attend. And we're also translating these documents. They are written initially in English, but we have translated already some of the documents, and we're in the process of translating more of them into Spanish and to other UN languages as well. And many of the NGOs are developing guidances on how to, in a way, simplify what is in these various documents. Okay, so I think it's useful to start by saying that the use of force by the police has in terms of international law, has a global component, a United Nations component, and a regional component. And you very well know the Inter-American one in where I am, the African one, the European one as well on the regional level. So I won't go into that, but I would like to focus then on the global one, the United Nations one. And perhaps the starting point is that the right to life and also the right against cruel, inhuman, degrading treatment or punishment, the right of peaceful assembly, that those rights are recognized in the Covenant on Civil and Political Rights, and also the right against ill treatment in the Convention against Torture and other cruel, inhuman, degrading treatment or punishment. These are the hard law instruments, but at the same time, a number of soft law instruments have been developed. So in 1979, the UN Code of Conduct was developed, and perhaps more directly relevant, the 1990 UN Basic Principles on the Use of Force and Firearms. The right to life, for example, has these two components of the substantive standards: when force may force be used, and when may lethal force be used, for example, and the procedural component: what are the rules on accountability should there be a potential violation of the substantive standards. And these documents that I mentioned all require both the substantive standard and the procedural element to be observed. Otherwise, there is a violation of the right to life or the right against cruel, inhuman, degrading treatment or punishment. In the last 5 years, I think the first document that I want to mention is the one that in a way codifies the procedural element of the right to life. How should investigations be done when there has been a loss of life, for example, during a demonstration? And this is the Minnesota Protocol. We updated it in 2016. It's been translated into Spanish. And the Minnesota Protocol then sets out what triggers an investigation. So when the state knows or should have known about a potentially unlawful killing, and then what are the elements of a proper investigation, so impartiality, promptness, and so forth. And that, I think, is quite an important document, and it's updated. It has the digital component now as well, and it's quite important to take note of. And also emphasizing it's not only when there are complaints, but when the state knows about a potentially unlawful death, that it has to be investigated. And also the Human Rights Committee adopted General Comment 36 on the right to life. We finished that 2 years ago in 2018. Now in 2020, two important new so-called soft law instruments were added by the UN, both in which I had the opportunity of leading the drafting process. So in the Office of the High Commission of Human Rights, the UN Human Rights Guidance on Less Lethal Weapons in Law Enforcement was initially launched last year in its unedited version, and now it's been edited as well, and it's available at least in English. We are translating it now into Spanish as well on the website of the in this particular instance of the Office of the Human Rights Committee. So that's the UN Human Rights Guidance on Less Lethal Weapons in Law Enforcement. So this is something Xavier and myself were talking about that earlier. When I was Special Rapporteur, I was working with demonstrations, and in many cases, I saw that weapons that are called less lethal, and initially they were called non-lethal, that they were used, but they often had lethal effects. So if tear gas is fired directly at a person, or a shotgun is used at close range, they can be lethal. But even if they're not lethal, they can cause serious injury. And so the important point there is, if one says that force must be necessary, in some cases less lethal weapons are used, and there is excessive use of force. Even if it's short of death, it still may be not necessary to use that level of force. So the Human Rights Guidance on Less Lethal Weapons tries to set out what are the standards on when force may be used. And let me say that as a starting point, of course, it's welcome that less lethal weapons are made available, but they can be extremely dangerous. And what this document then tries to do is to be the first document that follows up on the basic principles of 1990 and now sets out what are the rules in respect of less lethal weapons. When do they cause problems? When may they be used legitimately? When may they not be used at all? So that's the first document from this year when it was launched in July in its edited version that I want to bring to your attention. And then the second one we finished at the end of July. This is in the Human Rights Committee, and that's General Comment 37 on the right of peaceful assembly. And this was a 2-year process. There were regional meetings. There was one in Mexico, for example. There was one in Geneva, one in Johannesburg, in Thailand, and so forth. And based on that, as a Human Rights Committee, we eventually passed a new general comment that tries to set out what are the rules on the management of demonstrations in general. So not only the use of force, it does focus on the use of force, but all the other issues as well. And I'll say something more about that, such as notification and what are the rules as far as allowing demonstrations are concerned, what are the obligations on the state. So the UN Human Rights Standards, of course, in the first place, I've mentioned the right to life, the right to freedom against ill treatment, but there are a number of fundamental principles that apply to all uses of force. So whether one is talking about firearms or whether you're talking about less lethal weapons, there are, I think, 5 really important principles that apply to all uses of force as far as the substantive part is concerned. And in addition to that, there's a procedural element that says that excessive use of force must be investigated and there must be accountability in the form that is appropriate. So as far as the substantive requirements are concerned, the first requirement is the one of legality, that rules governing the use of force, including on weapons that may lawfully be used, must be set out in national legislation or in other parts of the law. State parties to the ICCPR are required to take all necessary measures to prevent arbitrary deprivations of life and excessive use of force, and this must be in the law of the country itself. So this website that I mentioned then sets out the laws as far as Chile is concerned, and that's really the starting point. The UN can only do so much. When things go wrong in a country, then we can come in, but the first line of defense is the country itself and the legal system of the country, and that must provide when may force be used. But in the second place, these provisions on the use of force in the domestic law must comply with the standard of necessity. That's the second substantive component, so it must be in the law itself. It must be, the force must be necessary under the circumstances. And so necessary then means that it must be required for a legitimate law enforcement purpose, such as arrest or handling demonstrations, not for the personal purposes or purposes such as punishment or teaching people a lesson. Those are not legitimate policing objectives on the part of the police. It must be necessary, and that really means then, yes, it must be for legitimate a legal purpose, a law enforcement purpose, and it must be the minimum force required under the circumstances as a factual matter to achieve that legitimate objective. And it must stop when it's no longer necessary. So if somebody is handcuffed, the person may be violent, but the person is handcuffed, the person is subdued, then the force must be stopped. So those are the elements of necessity, that it must be the lowest level of force that can be used to achieve the legitimate objective. So it's not enough to say that I'm using a less lethal weapon. It's not a lethal weapon, and I've used tear gas or I've used a shotgun, and for that reason anything goes. It is also a question whether it is really necessary to use tear gas in that particular case, In some cases, it's not necessary to use force at all, even to effect an arrest. So the first threshold is it necessary to use force? And if it is indeed necessary to use some kind of force, it must be the minimum level of force. So legality, necessity, proportionality, so that there's a balance between the detriment that is caused to the individual concerned, for example, the injury, and the benefit that is obtained. So this is the weighing kind of exercise that one has to go through. So necessity is almost a ladder, and one should not go up on the ladder beyond what is necessary. And then proportionality says, but there are certain points on the ladder beyond which you cannot go. So if the only way to stop the proverbial child who stole an apple, the child is running away and the child is faster than the police officer, and factually the only way in which the police officer can stop the child is to shoot the child, that may be necessary in the sense of this is the only way in which this can be done, but it's not proportionate. And for that reason, it fails on that level. So any force must meet the requirement of legality, necessity. It must also be proportionate. So these are all cumulative requirements. And then in the fourth place, it's widely recognized today that precautionary measures must also be taken. So if a situation where the use of force may come in can be avoided in the first place, like in the McCann case, then those precautionary measures should be taken. And this also then means that the police must be equipped with the right equipment. If they're only equipped with, for example, firearms, then this precautionary measure is not taken. Maybe in the end they're in a situation where they have to defend themselves and they can only do so with firearms, and may be necessary, it may be proportionate, but they could have avoided the situation altogether if they had proper equipment themselves, and if they had less lethal weapons, appropriate less lethal weapons, or they could have diffused the situation. So precautionary measures, the fourth element. In the last place, any use of force must be non-discriminatory. It cannot be based on race. It cannot be based on somebody's political opinion. It cannot be aimed specifically against women or against people based on their nationality or sexual orientation or anything like that. So these are the requirements, the substantive requirements, the 5 requirements for the use of force. And then there's also the procedural element, that potentially unlawful use of force, there must be accountability, which means there must be an investigation, and then there must be a remedy, and also, if need be, there must be steps taken of reform as well. So there's specific rules on firearms, as we have, for example, in Basic Principle 9, that firearms aimed specifically to kill somebody may be used only in the case of an imminent threat to life. And with that, we mean something within seconds that will materialize. So it's in self-defense or in defense of others. So those are the general rules, and they then further described in the document, the guidance on less lethal weapons. Zafir asked that I say something about how that document was drafted. So in 2014, I recommended to the Office of the High Commissioner for Human Rights that such a document should be drafted to supplement the basic principles on the use of force and firearms. And then the Geneva Academy and myself got together, and we got a technical group, and we worked with the office then, and we met with police officers, and we met with the lawyers and medical doctors and others. And we then, I think it was a 3-year process, we drafted this new document on less lethal weapons. So I look forward to discussing that. I know there are issues about the use of pellets and shotguns in the Chilean context, as is the case with other countries and with other less lethal weapons as well. And so I'll be glad to discuss those. In general, we say in the guidance on less lethal weapons that if a kinetic impact mechanism such as a shotgun is used, it must be accurate within a diameter of 10 centimeters in terms of its target, and that shooting multiple projectiles at the same time, this should not be done because of the inaccuracy that this entails. And I've also heard about the extent to which this has caused eye injuries, and I think 182 cases in the recent months in Chile, and that's something that we addressed in the less lethal guidance. In the last place, I want to say something briefly about the General Comment 37 that we adopted in July, which, as I mentioned, deals with demonstrations in general. So the less lethal guidance deals with the use of less lethal guidance in any context, in particular in demonstrations, but it doesn't deal with demonstrations in general, and it does not only deal with demonstrations, it deals with arrest as well, and enforcement of lockdowns and so forth, any case where, in the instance where the police may use something other than firearms. So the General Comment 37, for its part, deals specifically with the right of peaceful assembly. So it deals not only with the use of force issues, but with the whole management of peaceful assemblies. But I think these two are very closely linked, because if one has a situation where peaceful assemblies are not properly managed and people don't know on all sides what to expect, it's very easy for that to get out of hand. So, for example, if there's not a clear guidance on whether notification is required, are the organizers responsible, and may the police, for example, require people not to wear face masks and so forth. If there's not certainty on that, the chances of things going wrong are much higher than situations where there is uncertainty. There's always a chance that things will go wrong, but you can reduce it if you have a proper management of the whole process of demonstrations, from when it's first organized to when it happens to when people go home afterwards as well. So the general comment, as I mentioned, was drafted by the Human Rights Committee. We've done now in total 37 such general comments to set out the law more clearly. The document essentially starts from the premise of maximum freedom as far as the exercise of the right is concerned, and any restrictions need to be justified. It's divided into 7 parts. First, the general remarks, and it says, why is this important? Why should states recognize a peaceful assembly as a basic right? And we emphasize that it's part of democracy, but it's also part, it's a value in its own. It's a way for people to assert themselves, to express themselves, to participate, and that a failure to respect the right of peaceful assembly is a marker of repression. So that's the starting point where we justify the right. And then the question is what falls within the right. So if one person holds up a poster, a sole demonstrator, is that an assembly? We say no, assembly means at least 2 people get together. And one of the other questions then was online assemblies. So the Me Too movement, for example, where it's not just the assembly that's organized using technology and communication technology, digital technology, but people actually meet each other and get together, gather online. Is that protected by the right? And so we had long discussions about this. In the end, all the committee members agreed that a large part of how people gather, that's the way we gather now, for example, here on Zoom, is done online, and is a very important part of social life, political life, of participation in assemblies today. And so it's recognized that assemblies can take place indoors, it can take place outdoors, it can take place in public property, it can take place in private property, it can take place offline, and it can take place online. And then there's the whole question, what is a peaceful assembly? So if there's violence, of course, then the question is, if there are 100 people and 10 of them are violent, is that no longer a peaceful assembly? So we say the question is the violence widespread and serious? And then also some assemblies may be deemed to be violence if there's the intention of violence, or whether violence is imminent, that may be deemed to be violence, and if there's incitement to violence. What is the obligation on states? There's a general obligation states to respect and ensure the exercise of the right. And then there's a negative duty on the part of the state not to unduly interfere with assemblies, and that's the most important thing for state to just let it happen. But there's also the duty to facilitate and protect these assemblies. So to facilitate, to block off streets, to protect is if people are attacked by other members of the public, to protect them. Restrictions must be content neutral. It cannot be based on the opinions of the people involved or how close they are to those in government. Time, manner, and place may be regulated, but it must be regulated that you are able within sight and sound to exercise your right. There's a level of disruption inherent in assemblies, and then we talk about anonymity, can people wear masks, and so forth. Notification in general, we say that notification may be required, but not authorization. You may not be required to ask for the right. Do you have this right in any event? And then there's a whole section on the use of force, which essentially refers to the guidance on less lethal weapons. And it talks then about preventative detention, stop and search. I'll be happy to talk about that, kettling and so forth. But maybe I should stop there and say that I think the net result of this is that peaceful assemblies, which used to be an area where there were different parts of the law that played a role, that there's now a much more coherent global framework for this. I think it's generally a framework that allows assemblies as far as possible to take place, and hopefully this will play some role in ensuring that assemblies can go ahead, can achieve their purpose, but also to avoid some of the excesses that one find on either side of assemblies in many societies where that can leave deep scars. So to recognize that assemblies play an important role, have played a very important role in history, especially in the last century, and this is a very important part of democracy today, that it will be protected and that it will be respected by governments as well. So thank you very much so far.
Thank you very much for your presentation. It's very interesting. I have several questions, and I think some of our people that is present here. So I want to ask our guests if they want to start with any question. Paul? Or
yeah,
Pietro?
maybe I can start if you want.
Yeah, go for it.
Okay. Good afternoon, Professor Haynes. First of all, I really want to thank you for your valuable work on the drafting of these documents, because they are being very useful for us to reflect about the legality or the illegality of the using of less lethal weapons in Chile in the last year. I have an important question for you, and it's about accountability, reparation, investigation, and so on, because in the guidance of United Nations, there are a few important rules about this issue. And there is a question that we are making ourselves about the necessity of a reparation program. So I want to ask you if you know any good national experience about a reparation program in cases of mass violation of human rights by the illegal use of less lethal weapons. Thank you.
Zafir, thank you very much. Do you want me to go to answer specific questions when they come up, or some questions together, or how do you want me to proceed?
Well, I'd rather if you can reply the questions as we move on. So like
yes.
Right now, and then we make the follow-up questions.
Yes. Well, thank you very much. So Paul, on the issue of reparations, to emphasize that the Minnesota Protocol, there we try to set out the rules on the accountability part. So the three elements: investigations, then some reparations, and also legal reform that may be required. And the Minnesota Protocol is focused in particular on loss of life, which is fortunately not always the case. But many of these principles apply also if one is simply talking about the excessive use of force. So what triggers the need for an investigation? for example, and then the forensics and how these investigations should be done, and the impartiality and those sort of things as well. And then on reform, as you know, investigation being the first one, and then reform, the last one. I do think that's the important one, is that in the long run, it's important that if the laws themselves are not in conformity with international standards, and looking at the domestic laws worldwide, it's in many instances the case that domestic law does not reflect international law. And that's very important that that is changed, because it's, as I said, the first line of defense. So if the domestic law recognizes the right, and in its substantive elements, but also in its procedural elements, that's already more than half of the battle won. But that's the long term. So reform does not resolve the problem directly. And so the one you're talking about is the reparations, which is then that if there are investigations, and that's the middle sort of one, if the investigations, then that must lead in appropriate cases to prosecutions, and it must also lead to compensation being paid. And the question there then is proper national or examples, I suppose, on the national levels where this has been done, where there's been large-scale violations and excessive use of force. So we did a research now in Africa in 6 countries where we looked at commissions of inquiry. And that was, the question was whether commissions of inquiry have an important role to play in this context. And initially we thought commissions of inquiry will, in the majority of cases, will be just smoke screens. I must say we did find in all 6 cases that we looked at in detail. So we went to the countries, we spoke to people concerned and so on. In all 6 cases where there was large-scale violation of the right to life, commissions of inquiry played a relatively positive role. In some cases, a very positive role in terms of eventually leading to prosecutions and getting evidence on the table, and in terms of getting community involvement and so forth. In some cases, they played a minor role. We didn't find any case where they played no role. And I know there are such cases, but for the ones that we investigated, we didn't. There's of course the danger that sometimes they are instruments of impunity, and so it's not a magic instrument to use. But I find that the combination of proper prosecutions and commissions of inquiry can, in some cases, especially if the judiciary is mistrusted, and if there is a record of the judiciary on its own not working, commissions of inquiry can, at least in these cases that we investigate, can in some instances result in results, even if it's not immediate. So one case was happened in Chad, and it was actually 30 years later that a commission of inquiry where right to life violations took place, in this case not demonstrations, but where the evidence was gathered, and then many years later it eventually led to prosecutions. So one element is the one of commissions of inquiry playing a role with the caution that they can also be used. In my own country, Marikana, where we had 2012, where we had a large number of people, more than 50 killed. There was a commission of inquiry. So far, no prosecutions. So that also happens, but there would probably not have been prosecutions in any event if it wasn't for the commission. So I think that's one of the areas that play a role. I think the other element that I want to emphasize is the role that civil society plays in this. And my own experience here is in terms of the use of technology. We have a group of students who participate in a global project with Amnesty International, the Digital Verification Core. And they look at videos that people take with their cell phones and so on, and they then authenticate this. And this has become, and maybe you follow this as well, but this has become a extremely valuable tool, so that they have these reconstructions of the scene. So then you can see when people came out and they have maybe 3 different videos of the same incident, and they then show from this angle, from that angle, at 2:25 this happened, and 2:26 this happened, and they can reconstruct. And as somebody said to me in Marikana, is that if you have that sort of thing, you will still get lies. But if you don't have that sort of thing, you will get big lies. So you may get smaller lies when you have the digital records and when you can use such material. And of course, it's important also for those who, civil society, who get involved in these things, to know they can rely on the evidence that they have, because there is often, you know, the word fake news has become used in different contexts, but it's true that in some cases, some of these videos are not authentic. I had the experience myself of presenting the videos that were taken of executions in Sri Lanka to the Human Rights Council. And if this was planted by the government, it would have been the end of my career if I go to the Human Rights Committee and say, look at these executions. So it's important that that is done. So I think that's the second element that I want to emphasize as far as reparations are concerned. And then also, of course, the fact that domestic law must be in conformity with the international standards, because otherwise there's very little chance that this will happen on the domestic level. So there's no clear, quick answer to it, and I know I focus mostly on prosecutions. Reparations on my continent often play a big role. It's not always prosecutions, I think it's also in these cases that we looked at that some kind of compensation, in some cases, it doesn't solve the problem, but in some cases plays some kind of role as well.
Thank you very much. Now I'm going to introduce you to Alejandro Fernandez. He's the Secretary General of the Universidad Católica de Temuco, and he has a question for you.
Thank you, Javier. First of all, thank you, Professor Haynes, for being with us. For our institution, it's an honor to have a member of the United Nations Human Rights Committee talking to our faculty. And as a human rights specialist, I'm personally thrilled. My question is, considering what happened in Chile with the police not following, or having insufficient protocols for the use of less lethal weapons, what kind of institutional or maybe legal transformation or basic elements are required in order for our police to comply with international standards?
Yeah, and I think that is really the heart of the matter. It's one thing for us in the UN to work on the standards and also on the regional level, and I think those things are important because that it sets out what the standards are, but the actual enforcement has to take place on the domestic level. By the time a case reaches us in the Human Rights Committee, for example, if individual communication comes to us, it's years later. This is a net with very, there are large holes in the international system in terms of protecting. It's much more important, and the first step is really to have it protected on the domestic level. So this has different elements and different dimensions. The one is simply the law itself, to make sure that the legal systems, both in terms of substance and in terms of procedure, so the rules on when force may be used, and also in terms of the accountability afterwards, that they're in line with the international standards. And I think these international standards are now readily available and can be used. But there are also many countries where the legal provisions, the domestic legal provisions, are relatively okay. But the question lies with enforcement. And enforcement, I think, depends on a number of things. The kind of work that you do as a university, training of people who will be on both sides. There will be some in the police, there will be some, some as NGO members, lawyers, and so forth. So the training is very important. I find in some countries that I visited as rapporteur that people who work in this field don't have access to the domestic laws, or there's great uncertainty about the domestic laws. So the training of the lawyers themselves who work in the police and private people and who will be in NGOs as well, that's very important. And then I think sorry, in the third place, the involvement of civil society in these cases. And this can take the form, that, as I mentioned before, of getting evidence, because often the dispute is not about the law, the dispute is about the facts. And the important thing is then to get it recorded and to be able to use the information, but also to bring cases so that people who have been in demonstration, or family members, for example, that they have people who can bring cases to the domestic courts and, if need be, to the international ones as well. And these things are extremely important, because you can have the books, you can have the law on the books and it's on the shelf, but if it's not used and picked up by people, then these laws on how assemblies should be managed, then they really mean nothing. So I think that availability of legal advice, of bringing also seminal cases, so to be able to bring a case where there's a high visibility incident that has taken place, that this is not just something that passes without notice. So there's strategic litigation going on, and one cannot litigate every case, but to choose the right cases, to bring them with proper evidence. It's also no use bringing a case unless you've got the evidence. So to make sure that you've got the evidence as well as possible, and to win such cases, those things I think have proven in many societies to be very important, to make sure that the domestic system is fully engaged. If one brings a case and the case is not well argued, or the case is not well presented, you're almost worse off than when you haven't done it, because then it seems like you are giving up on this and you're not reconfirming the norm itself. So I would think those are some of the important elements.
Thank you. Well, one question I want to make to you is that in Chile, the police knew since 2012 that the ammunition that they were using was lethal or close range, and because it was pellets, they knew that at 30 meters or more, the dispersion of the projectiles make them very dangerous for everyone who was near. They never published that, they never made public that report. We only know that because that report was leaked to the press last year. And the guideline that they developed for the use of force in 2012, 13 and 14, and then in 2009, they always label this ammunition as non-lethal, and they do not incorporate their own assessment to the police. Because of the legal activism that we have been doing in courts, on June, for the first time, they released an update of these protocols, acknowledging that this ammunition could be lethal and they should not fire at close range to the upper part. However, the question, I have been reading a lot of what happened in Northern Ireland and in France and Spain and other countries. And one thing that worry me is the fact that in several countries, these weapons are introduced before a proper control or a proper acknowledgement of the risk that they entails are being made public. So, so right now in Chile, there is a lot of concern of the misuse in individual cases, but I think that there is no much talk about how should we regulate how the police, what the police decided to use and when it could, because
yes.
For one hand, it's like how we control what the police introduce as a weapon, and then the problem how there's guidelines. And I think that some of these topics emerge in your work. What can you tell us about this?
Yes, and it raises a lot of issues. The first is just the term non-lethal. So that term was used in the basic principles in 1990. But it soon became clear that these so-called non-lethal weapons are in many cases still lethal. And we know of many instances where people were hit in the head with tear gas and with rubber bullets and so forth. And so even the terminology is important because non-lethal gives the sort of sense, a false sense of security. So the term now is less lethal weapons, but that still gives a sense of false security because this sounds like this is not lethal, and it's almost in a carte blanche. And there's the danger that psychologically people think, well, at least what we're doing now is it's not something that is on that level that you have with firearms, and they relax, and then it's very easy to have the abuse of these weapons. So the terminology is important, and it's much better to use the term less lethal weapons, but that doesn't solve the problem in itself. So one of the main elements of the new guidance on less lethal weapons is to emphasize that there's a requirement to test weapons before they are used, to test these less lethal weapons. So as you will know, there's that requirement in international humanitarian law that weapons must be tested. But it was not explicitly stated before in the situation of law enforcement, and I think I think that this obligation was always there, but it wasn't explicitly mentioned. It's part of precaution, it's part of proper police procedures, but now it's explicitly mentioned. And so the two things I want to mention there is that. This is a requirement now, that weapons must be tested. And then, of course, we say that shotguns should not be used at all. Whether it's 12 pellets or whether it's 2 or 3 pellets, it should not be used at all. This is in the less lethal weapons guidance. And the force continuum then says that one should use, also before you eventually get to firearms itself, that instruments such as tear gas and so forth should be used. Now, this is not to say at the same time that tear gas is wonderful and that there are no problems there. With tear gas, there are also problems with excessive use. And there was recently, I think Amnesty issued a study in which they show how this is often used in excessive quantities. Of course, if it's used in confined spaces or if it's shot directly at people, that it can be lethal, but also just the level of oppression. You can imagine if tear gas is used at every assembly. In my country, there are 12,000 demonstrations per year. And if tear gas is used at all of them, the overall level of oppression becomes very high. And in many cases, people have to get some medical treatment and so forth. So it's not that tear gas is the answer, but shotguns are even more problematic, also because of the impact that it has on eyes and so forth. So there is this force continuum, and what is taken out of the equation is these inaccurate weapons, such as the use of shotguns.
Thank you very much. On this line, one discussion that we often have is the fact that the United Nations can only suggest guidelines. They can't regulate the matter for the individual states. So one discussion is like, we should, as a country, Chile as a country, should use these guidelines to start building over it. I was reading a paper by Terrell and Pauline, the researchers from the US, which discovered in 2017 that the police that has more regulation, more restrictive regulation, were police that use less lethal weapons less. So it seems that the suggestion is for create more restrictive and more proper regulations rather than create very generic guidelines for the individual use of force in the country. How do you view like the suggestion that you can make from the United Nations, and which should be the commitment that the individual state should do in terms of more or less regulation, or which, how do you see the tension?
Yes, so the guidelines that we have, the general comment that we have in itself, of course, is not directly binding. But the general comment, for example, is as we see it, authoritative interpretation of the covenant, and states are parties to the covenant, and there's a particular right there on peaceful assembly and the right against cruel, inhuman, degrading treatment, punishment, the right to life, and so forth. So it's an interpretation of that. But so it's this question of soft law and hard law. I think it's also important to keep in mind that this is not a complete distinction, because there are so-called hard law provisions which are often not really taken very seriously, and soft law provisions which actually, like the basic principles, which over the years really become quite authoritative, and in terms of its general use has sort of hardened up in terms of its applicability. And so certainly in terms of us assessing in the Human Rights Committee, and the same happens with the other regional systems, we use these guidance to assess the conduct of states. But that's on the international level. On the domestic level, if I understand your question correctly, is about whether more regulations have a more of a restraining effect on the police. And I think it seemed to me clear from various countries that the question is really how specific are these regulations, and how up to date are these regulations. In many countries, the regulations and the standing operating procedures, and there are pages and pages of those, but they are so out of date, and they are so clearly no longer in touch with the reality, that the police don't really use them. It's very hard to find a copy of it. So I've been in countries where I met with the head of police, where I meet with the Minister of Justice, and they simply cannot find the regulations. It's somewhere there. So it's not really the quantity of the regulation, but it's how up to date these regulations are. And to some extent, I would argue that in some instances also more focused regulation is probably better, because if you have, for example, in some countries, you have various pieces of legislation and also of regulations, and the police officer then has to think, oh, is this something which is done under the arrest, or is it under the demonstration regulations? It becomes very confusing, and it's difficult to teach. So I've, for example, have argued in South Africa that we should put all our use of force laws into one, so that it is more accessible and it's easier to train people in terms of that, and that there's no possibility of inherent conflict and people not sure which one is applicable there. So I wouldn't see it as the quantity of the regulations, but the point that I want to emphasize, that you also picked up on, is the importance of the domestic system doing that, and how far the domestic systems in many cases are from the international ones. There are terms used such as, it must be, any use of firearms must be directed at the legs, nothing more. And all necessary force may be used, nothing more. All reasonable force may be used, nothing about proportionality and those sort of things. So I think it's important that these 5 elements that I mentioned before, as far as force is concerned, that they find their way into the domestic laws themselves and into the regulations, and that these regulations are updated as one goes along, even if they're not completely in compliance with international standards. But the fact that they are there, and it's last year the police looked at them, and where they could, they brought them more in line, is more important than having a lot of regulations that come from 20 years ago.
Yeah. Well, in Chile, the main issue that we're having is the fact that they have certain regulations, certain guidelines that address or recognize the United Nations and the principles you mentioned, but at the same time, it seems that there is a disconnection. Like they seem that these guidelines are for the public, but internally, they do not release their own real protocols, and we don't know how they organize them. So there's a disconnection. Yes. Paul Rocher is from France. He has a question. Paul, please.
Okay.
Do you hear me? Can you hear me?
Yes, it's not very loud, but I can hear.
Well, I'll try to change. Is it better now?
Yes, yes, very much.
Okay, thank you for your presentation. You've been talking about necessity and proportionality as like key elements of regulation. And something I've been working on, and which was like, you know, puzzling me, is that when working on French data on how many times the police use this and that non-lethal weapon, what I observed is that in a context where demonstrations did not get really more violent, there was a huge increase of use of non-lethal weapons. If you compare the data from 2009 to the data of 2018, you have a multiplication by 9, and certain weapons, like kinetic impact weapons, they had even a much bigger increase. So what I'd like to know is what you think about the idea that because you make non-lethal weapons available, this tends to increase police brutality, because it suggests to the policemen that basically the weapons are not that dangerous and therefore you can use them all the more. So that was something that I found like worrying. So I would like to have your opinion on that.
Yes, yes. No, I think this is very, you are very right. If one considers a situation where previously a police officer may, for example, just have a firearm, it takes, if all goes well, it takes quite a bit before they use that. And so there's a threshold that has to be met. If they have tasers, for example, if they have shotguns, rubber bullets and so forth, it's much easier to reach that sort of threshold. And so this is a difficult situation then to balance. Does one want a situation where if force is used, it's used less often, but it's lethal force that is used? Or do you want a situation where force is more often used, but it's less lethal in how it's done? And I think it's a relevant problem that one says that the whole notion of less lethal weapons is almost a license to use force. And if one adds up all the uses of tear gas and all the uses of rubber bullets and so forth, that can be very, very repressive. So the whole idea of democracy and the idea of people being able to go out, it has a chilling effect because it's used, and it doesn't end up in a trial of murder or a trial of culpable homicide, but in many cases there are serious injuries that there arise as a result. So I think that the challenge is to say, how does one push in the direction of the lower level of force being used, less lethal instead of lethal, but also to make sure that it's not used excessively. That's where training, I think, is very important. So the question is how to constrain then this, exactly the point that you've reached, that you've mentioned, the widespread use. The training of the police officer is very important, but also the role of civil society monitoring that, exactly the kind of study that you mentioned, the 9-fold increase. So that's a quantifiable approach that can be used to say that it's better that less lethal weapons are used, but it can very easily be abused, and this should be taken note of, and it should be addressed. So I fully agree with you that this sort of research is very important, and this is indeed the danger. It's almost a Foucault kind of thing, is that the repression takes a different form. And I think that is something very important to address. Zafir, if I may just go back to your point about transparency, that the real standard operating procedures are not known. That is a very important point as well. And I think a point that needs activism and needs support from civil society to ask, what are these rules? One particular country, after the less lethal weapons guidance was issued, did contact me and asked me to work with them on their standing operating procedures, and we did that. We finished that a few weeks ago. That was also not done in a very transparent way, but at least it's encouraging to me that they did this, and they're bringing their regulations more in line. But in the long run, this is only going. So this is fine when it happens every now and again, But in the long run, there must be transparency about these rules, because that's the social contract, is what can people expect from their government. And this is where the government and the population meet, and it's often a very volatile sort of situation. And what are the rules that govern us?
This is not, we have technical issue. Christopher, can you hear us? Said that we have a technical issue. Okay. It's me, or it's like I think that we lost Christoph Haynes.
Yes, we lost him.
Oh, hello, Professor. Oh, there you are. Sorry, you have to unmute your mic.
Sorry, yes, I lost connection there. But yes, I was also wondering whether transparency, the access to information laws, whether that can be used to get access to what are these standing operating procedures and regulations on the use of force.
Thank you. Well, I have two questions. One is that I have been reading a lot of the work of Omega Research Foundation, Stephen Wright, and now I have been talking with Matthew McInboy.
Yes.
One of the issues that have arisen is how this lethal weapon has been increasingly, there is a market for these non-lethal weapons, and they have been incredibly they have been started to increasingly being used for as a way or as a mechanism of torturing people. So there is any chance like that we can discuss at least from the international law of human rights, to ban certain of these weapons, or to propose certain standards or limitation to what can be made, what can be designed, what can be sold, because the problem is the market. And which are your views on this topic?
Yes, and it's also, of course, in terms of the trade in these weapons, it's not just to governments, but it's also to private security providers. And there's a huge market for this. It also brings in issues such as the use of drones and other technologies that can be used to disperse these sort of weapons. And so I think the important things here include then the requirement for states to test if they're going to buy something somewhere. They cannot simply assume that because it's available on the market that it is actually legal and that it complies with international standards. So this emphasis on them needing to test it. But there's also the issue of trade in these instruments of torture, which I think needs more attention from the international community, because in many cases there would be a private security company that buys for 10 countries or 20 countries where they use it. And this should be regulated by the countries in question. They must assume responsibility for this. This is not just because there is a multinational private security company that brings it in, that this is now how things are done in that particular country.
Thank you. I have a question from Veronica Nostroza. She is telling me about that in Colombia, I think yesterday, the police used taser against a lawyer and they killed him. So the question that she's making is concerning about these arbitrary executions, the use, how to construct a case where police abuse of these weapons ended in an execution, or an arbitrary execution. Which are the suggestions for the investigation and litigations in court of these cases?
Yes, and there are, of course, limitations on where tasers may be used at all. I do not know the facts of this particular case, but if it's a pre-existing medical condition, or if it's used in a situation where the person was already in an elevated position and fell off and hurt himself in that sort of process, this is clearly a situation that triggers the duty of investigation. And the question is also then, is there a pattern? It's not only if in that particular case this person died, but whether there's a pattern of abuse, which then puts a stronger emphasis on obligation on the state to act in preventing such situations from occurring in the future. But this is the typical sort of situation that will trigger the duty of investigation. The fact that it's within this, I assume this is in the demonstration itself that it took place. That's also any use of force used by the police have to be reported. It has to be investigated. So there's no doubt about it that such an instance should be properly investigated.
Thank you. Well, I want to thank you for your time, for being with us today, for sharing your knowledge with us. I thank everyone who has been with us. And again, thank you for being with us. It's very important. It's an issue that we have been dealing, and we're going to continue to be dealing with. And thank you very much.
Thank you very much for the opportunity. This is something that I will remain engaged in, and from the UN side we will remain engaged in. And so we're looking forward to collaboration with people like yourselves who are on the ground, where it's really important how these standards are applied in the concrete situations.
Thank you very much.